May I, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 5, Your Lordship.
Hmm.
May it be please fixed after the break, Your Lordship.
Why?
Because Mr. Aris Nawam, he has some difficulties today, Your Lordship.
Hmm?
Mr. Aris Nawam, he has some difficulties today, Your Lordship.
On the ground that Mr. Aris Nawam, Learned Additional Advocate General, who is entrusted with this matter, has some personal difficulty today. Come on. Mr. Y. Learned Counsel, State Council, request for listing of the matter after 2 weeks. 3 weeks, huh? Praise the Lord, list after 3 weeks.
And Your Lordship, item number 23 as well.
Why 23? Same.
Yes, Your Lordship.
Who is for the petitioner?
I have taken the consent, Your Lordship, in both the matters.
Same order. Item 23.
Oblige, Your Lordship.
Item number 1.
My lords, I beg to appear on behalf of the petition item 1. This is a matter in which we have approached your lordship for seeking protection from the state. May I invite your
No, there
lordship?
is, you have already been protected.
My lords, in fact, now I mean, effectively they're in contempt, my lords. Kindly see your lordship's order of 12th of May, the last order. And please see paragraph 7. After the learned AAG had admitted that there is some serious apprehension, kindly see para 7, the directions.
Yes.
The first direction, my lords, is respondent state authority shall continue to provide adequate interim security protection to the petitioner whenever he visits or remains within state of Arunachal Pradesh. Now, my lords, I am informed that whatever protection I was getting earlier, that has actually been reduced today. Thereafter, your lordship and number 2 had directed the Ministry of Home Affairs to expeditiously consider my petitioner's threat perception and security categorization.
No, that order has already been passed.
But nothing has been done, my lords. There is no status report by
How
both
do
the
you-
governments. There is
Sir,
no
in that
action at
case-
all.
You file an affidavit.
My lords, today they were supposed to file at paragraph 8. Your lordships had directed them to file a status report. There is no status report after 2 months, my lords, both by union and by the state. They ought to at least respond to your lordship as to why this order has not been complied with.
Yes.
Malad, in fact, the order passed by this Honorable Court has already been communicated to the Ministry, Malad. By Malad, the letter dated, Malad, we have also communicated by way of Malad.
Sir, communication will not be enough. When the order is passed, a
Yes.
judicial order is passed, simply communication will not do.
By mail, Malad, we have already sent to the Malad, the Ministry for compliance, Malad, for the, as per the order passed by.
So what happened? You are supposed to file the status report.
Admittedly, Malad, there is no any instructions from the Ministry, Malad.
No, that is the problem. That's why I'm saying when the order is passed, judicial order is passed, you have to take care of that. Just simply communication will not do, sir.
Malad, in that case, may I pray?
We don't pass orders just to remain in the
Yes,
paper.
Malad, may I pray that, Malad, in that case, Malad, matter may be posted day after tomorrow, Malad. In the meantime, I'll come with affidavit, Malad.
Day after
I'll come with instruction, Malad.
Day after tomorrow will be Sunday.
Sorry, Malad. On 1st July, Malad.
I have no
Monday, my
problem.
lords.
I have no problem. You may.
But let them fully comply, my lords. Also, because your lordships had directed that my application
Let
should
us-
be considered within 4 weeks,
Just wait, sir.
my lords.
We have our instructions, my lord, report, but we have not filed it in the form of an affidavit. My lord, we are reiterating the same stand that we are yet to receive the threat perception assessment reports from other agencies. And we have said that this will be placed before the committee, Security Review Committee, very soon, my lord.
You file a status report by Monday.
By Monday,
We'll list it on Monday.
Lordship, please.
All right, sir.
I am so grateful, my lords.
And on Monday, if nothing is coming forward and nothing comes forward, you avail the remedy. We'll take action.
Lordship, please.
Heard
Highly grateful.
Mr. Dr. D. Baruka,
Lordship.
Senior Counsel, assisted by
A.K. Pandey, my lord.
A.K. Pandey, Learned Counsel for the petitioner. This court on 12/05/2026 directed the state authority to provide adequate interim security to the petitioner whenever he visits or remains within the state of Arunachal Pradesh, commensurate with the prevailing threats perception. No, you just write, this court pass the following directions, huh? Para 7.
Hello.
Next para. The senior counsel for the petitioner submits that the order of this, the above order has not been complied with. Direction and order has not been complied with by the respondent authorities. List of next para. It is seen that no status report has been filed except the communication from the Superintendent of Police within bracket Security Itano to the Senior Government Advocate, which has been placed by Mr. N. Ratan Lanet, Additional Advocate General. List of considered above. Let this matter be listed on Monday.
Well.
Monday, that is 29. 06/2026, on which date the learned counsel for the respondents, particularly Mr. You are which one?
I'm for the Union of India.
Mr. M. Kato Lanet, the DSJ, and Mr. N. Ratan Lanet, additional file, invariably file the status report. You file in the
Highly-
morning, we'll take it up.
Highly grateful. That's-
Item number 2.
May I please, Your Lordship?
Yes, sir.
Matter is related to Lordship,
Hmm.
praying for direction to the respondent authority to redesignate our post that is presently holding the post of assistant,
Project officer.
yes, project officer. Initially, Lordship, we are the employee of the DRDO.
Hmm. Hmm.
And when the DRDA was winding up,
Let us,
Then-
we'll issue notice.
yes,
Heard Mr. M. Bhatt, learned counsel for the petitioners. Next para, this petition is filed seeking designation of the post of assistant project officer as block development officer and the Department of
rural development.
Rural Development, Government of Arunachal Pradesh, on the ground that the petitioners, on being absorbed
Yes, permanent.
from the Earthwell DRDA
DRDA.
in the Department of Rural Development, the post of assistant project officer being held by assistant project officer being held by the petitioner has not been redesignated, whereas the higher post in the actual DRDA, what is that higher post?
Pardon?
PD,
PD,
project
the higher
Project
post
direct-
is PD,
project
project director RD.
has been redesignated as
Yes.
project director.
Project director RD,
Rural Development.
Deputy Director RD. Oh, but
List.
here as per notification project.
This is their
But this is
submission.
yes, yes.
You cannot have any objection.
My lord.
Next para. The petitioners were appointed as were working as assistant project officers originally, and they were the employees of district rural development agencies. List of upon amalgamation of the district rural development agency, the employees, including the petitioners, have been absorbed in the Department of Rural Development, Government of Arunachal Pradesh. List of the petitioners contends that in view of redesignation of the petitioners after the absorption, the chances of the future prospect, future career prospect, including the provision, including the avenues of provision, are promotion, sorry, including the promotions, are being completely sealed. List of next para. Issue notice returnable by 4 weeks. You are appearing. Who else are appearing?
Two entry, my lord.
Mr. MS Arbasar, London State Council, and Mr. B. Piche, London Standing Council, Rural Development Department, and this accepts notice on behalf of all the respondents. No formal notice need be. However, extra copies be shown.
One interim prayer also.
What
there,
interim
Lord.
prayer?
No, there is a 20 post which is holding by the joint BDOs and APOs also as a in charge. That should not be filled up till
If they are insisting on
final
interim, my
disposal.
lord, I have to
That
raise
is
the
my-
objection to maintainability of this writ petition,
Well,
my lord.
But first you will have to read.
Yes, sir.
Otherwise-
Whether writ petition itself is maintainable or not.
That's why I just recorded.
Yes, yes, ma'am.
I think at this stage no increment.
My lord, yes, yes, ma'am.
oblige.
Item number 3.
My lord, for convenient, my lord, item number 4 be taken up, my lord. It's similar nature, it's for
Why?
convenient, my lord.
Why?
My lord, for factual clarity, my lord, item number 4, my lord. It's similar only.
Do you think this court will not be will be
No, my lord.
confused?
My lord, not that exactly.
Yes.
My lord,
Where's the cancellation?
my lord, cancellation is at page 88, my lord.
88.
Yes, my lord.
Yes.
Now,
But
page 88, my lord. I
It-
was,
And
and thereafter, my lord,
the fresh NIT.
NIT, my lord, that is, before cancellation, NIT was page 87, my lord.
Hmm.
On 3rd June 2026, my lord.
87.
Yes, my lord.
Hmm. 87.
Yes.
What is percentage? Press notice. They heard Mr. Tita Land Council for the petitioner. Next, where the petitioner is the challenge made in this writ petition is to the press NIT. That it?
Dated 03/06/2026.
Where do you get it?
My lord, page 87.
03/06/2026, issued by the Commandant Engineer, Border Road Organization. All right.
Yes.
No, Indo
ITBP, my lord.
Commandant within bracket Engineer, Indo-Tibetan Border Police, Itanagar, Arunachal Pradesh, whereby notice of tender has been issued for construction of administrative block and quarter guard building at 25th B and ITB BP Teju, Arunachal Pradesh by way of fresh, by cancelling the earlier tender process dated.
My lord, the tender process
No, no,
dated
no, no.
12 November 2025.
Please stop.
12/11/2025.
Two sentence you delete it. Arunachal Pradesh. Please stop. The petitioner also challenges the corrigendum that is 0406/2026. Issued by the Commandant Engineer, ITBP, by which the earlier tender dated
12/11/2025, my lord.
12/3,
12/11, my lord.
11/2025 is sought to be cancelled on the ground of lesser participation, or on the ground that due to lesser participation, the price reasonability and the competitiveness could not be justified. List of next para. It is the contention of the petitioner that pursuant to the NIT dated
12/11/2025.
12/11/2025 for the same tender, i.e. construction of administrative block and quarter guard building at 25th Battalion ITBP, Teju, Arunachal Pradesh. The petitioner, along with
9 others.
9 others, have participated in the said tender process. List of upon evaluation of the technical bid, 3 bidders, including petitioner, were found to be found
Technically qualified
were
for.
declared technically qualified. Thereafter, upon evaluation of financial bid, the petitioner was declared L1. List of the price quoted by the petitioner was 16.58% below the estimated cost put to tender. List of it is contended that the petitioner were asked to produce original documents for verification of the verification before issuance of letter of acceptance and approval, to which the petitioner has acceded to by submitting the required by complying all requirements.
Mal.
List of next para. The Mr. Titagum, Land Council for the petitioner, submits that when when 10 firms have participated in the tender process, the cancellation of the tender process dated 12/11/2025 is not sustainable in view of the fact that the reason for cancellation is only on the ground of lesser participation for which the price reasonability and the competitiveness could not be justified. Mr. Issue notice returnable by 4 weeks, 3 weeks or 4 weeks,
My lord, 3 weeks.
3 weeks, 3 weeks.
Yes, my lord.
Next, you are appearing for all.
For all the respondents.
As Mr. M. Kato Leonard, DSGI, accepts notice on behalf of all the respondents, no formal notice need be served. Our extra copies will be furnished to the Land Council for the Land DSGI. Please, no. Then,
My lord, I have an interim prayer, my lord. My lord,
Interim prayer.
this is, my lord, interim prayer, my lord, exactly similar, my lord, is clearly covered. My lord, recently, the Honorable Supreme Court said that the tendering authority cannot cancel the already tender concluded only on their expectation that there's a possibility of getting more participation or higher the price bid, my lord. This is recently,
I don't think so. It may be different on
my lord, this is on
that case.
my lord, it is on my lord, my lord is aware of the Golden Food Product India, my lord. This is
Keep it yourself.
my lord,
Place it, relay it in the appropriate time,
my lord.
not today. Yes. Will stay the proceedings.
My lord, since already notice has been issued,
See, 10 firms, they have participated.
My lord.
Enough.
although with an 9 participants.
Next, para, considering that in the earlier tender process, 10 firms, including petitioner, earlier tender process, earlier tender NIT dated
And
11,
I did it 12, 11, 2020.
2025 for the same work, comma, the 10 bidders have participated and the petitioner having been found L1 was directed to furnish all the required documents, which was nearly completion of the tender process. And also, and the ground for cancellations primarily appears to be contrary to the records, contrary to the fact that there were the reason for cancellation for more competitiveness, lesser participation of the bidders and for more competitiveness, comma, I deem it appropriate to pass. I'm of the considered that an interim order is called for at this stage. List of accordingly the NIT dated 03/06/2026 and the subsequent corrigendum dated 04/06/2026 cancelling the earlier tender NIT dated 12/11/25 shall remain suspended till the returnable date.
Deeply aware.
Then
My lord, this is also the same, my lord.
administrative.
Yes, my lord, this is not administrative, my lord. There's a
Earlier tender process,
earlier
And
tender
that is-
process 16/2/2026, my lord.
16/2/20
26, my lord.
and
And In the technical bit, my lord, altogether 4 participant,
Just
farm
one-
parts,
Just one by one.
my lord.
Number one, the fresh the NIT.
Fresh NIT, my lord, at page 77, my lord, on dated 7 June 2026.
Fresh NIT, that is 0706/2020 is corrigendum.
Corrigendum, my lord,
There's no corrigendum.
yes, corrigendum, my lord, 0506, my lord, page 76.
76. Corrigendum.
0506 2026.
0506. 76.
Yes, my lord. It's a corrigendum, my lord.
0506/2026. And then the work,
My lord,
construction of
construction of my lord, at page 37, 32 is the NIT, my lord.
same 77.
Construction of
Clothing Ration is the copy office, company office,
clothing, my lord.
Jawan Bereka, page 77. And then
My lord, thereafter, my lord, the
4 farms.
4 farm participants, page 71, my lord.
And then
Out of that, my lord, 3 qualified for financial bid, my lord. And the petitioner is, my lord, L1, my lord. Page 37, my lord. Page 73, my lord.
same.
Same, my lord.
Well, just a small submission, my lord. Without my lord, I may be allowed to take instruction.
And just wait. And then the price.
Price, my lord, it is below 7, my lord, below 7%, my lord.
Below
From-
7%.
13, roll, sorry, my lord, it's 13%.
30.
13% below estimate cost put to tender, my lord.
It appears to be huge.
Huge, my lord. And earlier also, my lord, because in case of this such tender matter, L1, the lowest one has to be given, my lord, is to be there, my lord.
It's
As
not
per
nec-
CBC, my lord.
It's not necessary.
It's, my lord, the reason there is, my lord, less participation, my lord. And also,
But in this case, 4 farms.
4 farms there. Out of that, my lord, 3 farm. The petitioner, number one, the petitioner happened to be L1, my lord, having quoted 13% below estimated cost put to tender. And thereafter, my lord, other farm also they are 6 point, below 6.2, my lord.
Same.
My lord, my only submission would be, my lord, instead of passing the interim order, my lord, I may be allowed to take instruction as because, my lord, the notice is
That's why we have issued 3 weeks.
3 weeks time, my lord.
3 weeks.
However, my lord,
In the meantime, you file the affidavit, bring all the records, we'll finish it up.
My lord.
If you want, we'll dispose it.
But the
on
notice
return.
has already been issued. Representation has also been filed before the concerned authorities. My lord, that is still, my lord, presumed to be,
You'll never consider me. You'll proceed and
my lord,
you'll decide. At best, you'll decide after the completion of the tender.
I'll
process.
come with instruction by Monday, my lord. In the meantime, my lord, matter may be kept, my lord. With
It's
instead
okay.
of,
We'll see.
Deeply obliged.
Monday we'll take some other matter.
deeply.
Item number 6.
No affidavit.
My lord,
Affidavit
my
has
lord.
been filed.
My lord, in affidavit, my lord, we have not yet filed, madam. I maybe get granted some more time.
Are you working still?
Well,
Have you been
they are
allowed
still
to work?
working. Still they are working, my lord.
Continue.
Continue. 3 weeks time, my lord.
Had Mr. M. Doji Learned Counsel for the petitioners. Is spread for by Mr. Titagum Learned Standing Council Education Department. Further 3 weeks time is granted to file affidavit in opposition.
Item number 7.
Lordship, union respondent has to file affidavit in opposition, but still they have not filed it, suppose.
The work is going on.
Lordship?
Work is going on.
Yes,
What what about the project?
My lord, project, it's about it, madam. The acquisition has been done and handing taking to done, madam. It's under my position, madam. The construction is going on.
Position, matlab,
Number 1.
It is, I've been handed over.
you are the
The developer, madam.
developer.
Yes, madam.
Okay.
Land has been acquired, madam.
Okay. Have you followed the law
We have followed, Mother. And,
provisions of the
Mother, in
it's a
fact,
forest land.
Mother,
Unclassified.
unclassified.
Still, I fail to understand what is unclassified forest, state forest. When I was
Yes, Malad.
that side,
Yes,
I tried to find out what is exactly unclassified state forest in the
Malad,
context of Arunachal Pradesh.
my lord, here,
Very difficult.
Godavaran case, where,
Godavarman.
yes, Godavarman, yes, my lord, the Forest Conservation Act, my lord, has defined forest for protection of forest. And whenever forest, any forest, which is to be utilized for non-forestry purpose, then the consent of the central government has to be taken.
No, that I've understood.
And-
But what I'm trying to say is the unclassified state forest in the context of Arunachal Pradesh.
My lord, wherever,
I
yes,
still, you work out something on that.
wherever forest cover, whether which has been recorded but not as a reserve forest or wildlife sanctuary. If it is a forest cover,
Because we have just, the state of Arunachal Pradesh has borrowed simply from the Assam Forest Act
yes,
and land regulation and other thing from Assam. So there's a huge, huge difference. So far as I'm not classifying or distinguishing it, but the tribals in the other part of the state and the tribal, so far as the holding of the land holding is concerned, is completely different.
yes.
Okay. How long?
We have filed our affidavit. It's the union.
Malad, the role of the union government,
But basically, sir, you are claiming that lands falls within your panchayat area.
Yes, yes, Lordship.
Whole idea is to get your land settled. Whether we cannot decide whether it's your land or someone's land.
Yes, Lordship, I understood.
So in that case, if there is a dispute between the ownership, which
Actually,
which area, which jurisdiction falls under, we cannot decide.
Yes, Lordship. Actually, this whole project has been commenced without identifying the ownership of the land. Simply, what they have done,
No,
they have
they are
shown.
saying it falls under this particular,
I am only-
particular jurisdiction. You are saying that it falls under the certain your panchayat area.
Yes.
This is something the writ
Eh,
court will not be able to decide.
No, I am only seeking.
Anyway, heard Mr.
N. Saha, Lordship.
and Sahalan counsel for the petitioners. And you have also filed the affidavit.
My lord, yes, I followed.
We have filed.
About the state of Arunachal Pradesh and the
Private respondent.
private respondent number
15, man.
15 have filed their respective affidavits. However, the Union of India is yet to file their response. List of, in view of the above, accordingly, As prayed for by Mr. M. Kato, Leonard DSGI, further 3 weeks time is granted. 3 weeks or 4 weeks or 8 weeks?
Lordship, this one.
4 weeks.
Lordship, already sufficient time has given. Lordship,
Yes,
my only
absolutely.
humble submission is that, Lordship, if entire record can be called up, because they are because they are not filing. And
We'll decide. It's voluminous. You have placed all the records. We'll see. Let them file.
because, Lordship, the basic
The
document.
only important, why we are granting him time, whether the provisions of law while,
Yes,
acquiring the land and all things, because you are claiming it falls under the forest, reserve forest.
Not-
You are saying it falls under reserve forest.
No. I'm saying it's not. It doesn't fall under the reserve forest. The
Ah.
classification of our community land as a reserve forest is wrong.
Huh.
Without hearing our grievances, though in
They are not saying that. They are not saying reserve forest. They say unclassified state forest.
yes, Lordship, unclassified state forest. Why I am saying that, but the process will be same, whether it is unclassified state forest or reserve.
No. That's why I'm saying I've just indicated. When I was that side, I could not I could not
My lord, unclassified
Find
state
out
forests and
what
beneficiaries
exactly
have been
the,
identified.
because unclassified state forest would be different from reserve forest. Reserve forest you cannot touch, right? Unclassified,
My lord,
the,
unclassified state forests,
Huh.
beneficiaries have been identified, they have been paid
Hmm.
those
It
owners.
has to be maintained, but that will be owned by this thing.
The
Tribal-
owners
I mean,
have been
the
identified
owners.
of this forest and they have been.
No, Lordship,
That is the
actually,
problem.
in that particular area, the
Because
area,
it's not the same. Reserve forest and unclassified state forests are not the same.
Not the same.
however, Lordship, but in that, the 2.33 hectares of land, which is the subject matter of this petition, in that area, there is no such beneficiaries. That completely they have abandoned this beneficiaries benefits.
Okay, 4 weeks.
And Lordship, one more
See,
thing,
after
I have already, this IA is pending in this case. IA may be considered
IA is
next.
for what?
Just Lordship, I have just
IA is for what?
limited prayer I have made.
Hmm.
Actually, due to in absence of any specific protection order from this honorable court, irreversible damage is going on. So if I want to preserve the land and land beneath and above whatever there is.
No, all these things, developing all this, what is called hydropower project.
Yes.
Only they have to comply with the provisions, required provisions.
But that's why
Okay, hydropower project, that's all.
that's Lordship.
Blindly, you cannot say that you don't do this, you do this, you cannot say so.
Lordship, whatever might be.
We'll consider, finally we'll consider. But prima facie, I mean, the way you have projected your case is something which this court may not like to go
No,
into.
Lordship, in specific hearing,
Already made subject to
specific.
writ petition.
It is made already.
Already.
No, this one, subject to outcome order, though order has been given, but in the absence of any specific order, that construction is carrying, by which we are being agreed, we are irreversible damages going on. My only concern is that preserve that property subject matter, because or else it might become in practice.
My lord, the area has been acquired by the government for following the due process of law. Matter. I paid the compensation. Now it is in the hand of the developer. Matter. Developer, it is the
Because Lordship, all entire process.
private public. Public,
Actually,
private
I am not
partnership.
feeling so well. Actually, so fever, but still.
No, you are perfectly arguing.
Yeah, yes.
Arguing perfectly.
Much obliged, Lordship. Lordship, actually, this one, there is lots of.
You have already granted them the
Lordship, there is lots of contradiction. Since from initial site inspection report to till now, there is lots of contradiction.
That's why we're keeping it.
So, Lordship,
We'll determine it.
at least for interim application may be heard next.
It's okay. There's an order to subject to outcome. What does it mean?
Yes,
If
Lordship.
you allow if the writ petition is allowed, consequences will follow.
But Lordship, that though all damage will be done, Lordship. My only intention is to preserve what is as it is.
No, unless we come to the conclusion that you are entitled for this particular land and it's your land, or the law has not been followed, how can we just simply say that? Because it will be unnecessarily interfering with the development in the other project.
Lordship, then those issues can be heard in that IA hearing only. If that's possible, Lordship.
We're keeping it pending with the writ petition. We're not dismissing your IA. Okay?
Okay. Obliged, Lordship.
Item number 8.
My lord, yesterday's item number. Yes, my lord, I have the instruction. Instruction is that they have all. It was correct that the
Component
has not been reduced. What my learned friend has tried to show that these components are being reduced. In fact, like pineapples, bamboos, and all, they are calculated per square meter. In 1 hectare, how many trees according to the density which is applicable. And it is given in the manual. So they don't count piece by piece, what I'm told. They count it in per square. So density as per the density, because it is impossible to count all by piece by piece.
It is more impossible to this court to comprehend.
Yes, yes. That's why there is no reduction. I'll just show.
No, quantity clearly shows. Simple one case. Pineapple.
Yes, pineapple. That earlier also.
What is that? Page 40.
40 and
Yes.
47 Lords.
40 and 47.
Yes,
Yes. 40 is the initial first assessment.
it says 500, and it has been reduced to 315. Now I'll show it from this manual. Why it is and what was the direction? Because how the compensation assessment has to be done. If my lord kindly see the page 101 itself. That is the manual. I'll show it, my lord. Page 101.
It's okay. How you have, see, simple. Let us go by simple arithmetic.
Yes,
See, for example, pineapple.
yes,
Quantity here is page 40 is 500.
yes, yes.
Right.
Yes,
Then page 47.
Yes.
yes. It is 315. How the calculation of 315?
No, we don't know. But
No, I'll show it, my
it
lord.
is
I'll
shown
demonstrate
that
it.
It is shown 300.
315.
315 Lords.
Okay, 315.
Yes,
Yes.
How it is calculated?
yes. I'll demonstrate that, my lord. Prior to that, page 101 of my
See, his simple prayer is you verify, go to
My
the
lord-
spot and re-verify.
my
As
lord.
you say that it may not be possible by, there's no activities now. The numbers and other things, particularly pineapple, may have been reduced. There may not be pineapple. You said pineapple 0 in that case, in front of them.
My lord, I'll first.
Or you have planted or cultivated? No.
No Lords.
I'll just.
We have not planted.
My lord,
But it cannot go beyond what was already assessed, even if you have the thousands. Because you have accepted the earlier one.
First assessment.
Simple, go and have a verification, that's all.
that otherwise the calculation is okay. It is.
We'll record it as per the manual. The calculation,
Yes,
second
yes.
calculation is as good as the first one,
Yes.
although there may be a variation in the numbers. But so far, the method of calculation is,
Earlier one also, my lord, I'll clarify. Earlier one also, they have never calculated it piece by piece. They have calculated it by density.
that.
Density.
Provide that.
we,
Have a physical verification, assess it as per the method applied
as per the manual.
as per the manual. We'll say that.
In presence of the petitioners.
Yes, yes.
Obviously.
Yes.
Now, once it is verified, assessment will be done by them only,
Yes.
Yes.
on the basis of the manual. What is the manual called?
This is 2022 land acquisition manual.
What is the particular provision?
That is annexure 6. That is the rates mentioned therein.
As per the manual will say,
Yes, as per the
verification. Let there be a verification in the presence of the petitioner.
Lords.
And then the assessment may be made
as per the
as per the manual.
Lords.
Is not it?
yes,
So,
yes.
This part of,
Lords.
let us not complicate it.
Yes, yes, yes.
Deeply obliged.
Even if you try to, explain, I'll not be able to understand.
It is. I have. I would have explained it very simply. That
Deeply obliged.
handing the land has already been handed over. So
It's okay, no issue.
yes,
And then over, you go and verify it again.
yes, my lord. A time frame may be given, my lord. Otherwise,
Within 1 month.
within yes, it will not take within a week.
20 days.
Within a week.
Within a week, my lord. Otherwise,
Within week will be
if
14 days. 14 days,
Okay.
you immediately issue a notice to,
otherwise, that's why in presence of the petitioners, if it is directed, if they don't come, that will create another problem. That
mark it and do it.
Yes, once
Yes.
notice issued.
Ah. Notice, issue notice
Within,
within 14 days.
within,
Notice will be
2
properly
weeks.
issued, Lordship.
Ah.
Yes,
We will appear.
within 2 weeks, madam. Yes, ma'am.
And notice maybe also Malak Sal's issued to the user agency.
Obviously,
Yes, yes.
They can.
all the stakeholders,
Yes.
including petition. I heard Mr. K. Lolen, learned counsel for the petitioners.
Hmm.
But also have Mr. Who is one? You are one. M. Kato, learned DAJ for respondent number 1, as well as Mr. Anderson, learned additional advocate general. For respondent number 1, 2. How many respondents?
2, 3, and 2 to 5.
2 to 5, huh? Dispose of. Will dictate in the
Deeply obliged, Lordship.
Item number 9.
Non-appears for the petitioner on call. What is to be done?
Your Lordship,
Compensation.
yes, Your Lordship. They're challenging the detention order, Your Lordship.
What is your,
We have filed our affidavit, Your Lordship.
you have filed?
Yes, sir.
He was rightly detained.
Your Lordship, we have also challenged them, we have put an objection to the maintainability of this writ petition, Your Lordship.
No, if we find that he was not illegally detained, we'll
Not-
dismiss the writ petition. What's there?
Yes, we have not illegally detained, Your Lordship. It was as per the procedure, Your Lordship.
Then we'll dismiss the writ petition. No maintainable. Will not issue on the, will decide on the maintainable. But where's the petitioner?
Yes. Otherwise, Your Lordship can record our affidavit and then take this matter for admission hearing, Your Lordship.
We need not record your stand. We'll just say list for admission.
Yes.
Non-appears for the petitioner on call. MST London additional PP for the state and Mr. Wairidam, State Council, London State Council are present. List for admission after 6 weeks. No, make it 4 weeks.
Item number 10.
Lordship, service report is still awaited.
Affidavit,
I'll be filing affidavit also and bit.
you are for?
Respondent number 5, 17, 52, 75, 79, and 127.
Office note dated 25/06/2026 reflects that service report in respect of respondent number 46, 7 to 16, 18 to 51, 53 to 74, 76, 77, 78, 80 to 126, and 128 to 143 are still awaited. Who are these respondents?
Lordship, there
What is the matter about?
for appointment order issued in the year between 2016 to 18, Lordship. Appointment order in civil engineering,
2016 to
18,
18.
yes.
Why you are challenging it? Anyway, Mr.
S.E. Ram, Lordship.
S.E. and counsel for the petitioner. And Mr.
M.
M. Tasso, as well as Mr. Wairidam, London State Council. M. Tasso, London Council for respondent number
5, 17,
5, 7,
5, and 17, 52,
17,
52,
52,
75,
75,
79,
79,
and 127.
127, as well as Mr. And Mr. Where London State Council are present, respondents, the appearing respondents to file their respective responses. List them after 4 weeks.
Deeply blessed.
Item number 11 and 12.
IA for what?
Sorry, Lordship. We are seeking implement of the present application as responded in WPC 228 of 2025. Lordship, this writ petition has been filed by the writ petitioner claiming the release of pending liabilities of 13 crore 93 lakhs 13,250 rupees against the state of Arunachal Pradesh Department of Food and Civil Supplies. Lordship, this bill is pertaining to a carriage bill for transportation of food items under PDS scheme to 11 villages under Boleng Circle, subdivision Siang District, Arunachal Pradesh. This work was awarded to MSTM Enterprises in the year 2001. And after the said work was awarded to TM Enterprises, the proprietor of the firm approached the applicant to execute the work in a partnership, which the applicant readily accepted. Lordship, as per the verbal agreement, the work was agreed to be executed at her own investment. But the 9% of the bill was agreed to be given to the firm proprietor. And subsequently, the work was duly executed. The work contract as per the verbal agreement and in terms of the agreement signed between the petitioner and the government of Arunachal Pradesh. And execution of carriage work and preparation of bill were done by the present applicant on behalf of the firm. And for claiming the liabilities, applicant has even opened an account in Apex Bank Limited in the year 2014. So for the convenience to pursue the bills, the writ petitioner and the applicant entered into two documents. That is agreement dated 16/4/2004 and power of attorney dated 16/4/2004. Lordship, this agreement is in page number 11 of my IA and 12. Lordship, my contention here is that the writ petitioner is filed without informing me and without my consent and without
By this page 11, what is this agreement?
This agreement is between
The petitioner and you.
yes, writ petitioner, the firm.
The petitioner shall pay 10% money to first from the total bill amount so received from the advance.
For the work which has been
Yes.
My lord, in this I have an objection. As my this applicant has submitted that there was a verbal agreement. There was no any such verbal agreement.
Anyway, but then there is an agreement
No, my lord.
that you will pay 9%.
No, my lord, this was executed. No date is there. Only date which is reflecting here, it is the countersign at the time of the countersign by the magistrate. And there is no any specific date when the power of attorney was
Are you
executed.
still disputing that you have not engaged the applicant?
No, but I have engaged only in the
If you
year,
have engaged, it's okay, we'll allow.
only in the 2004. Work was already carried out by me from 2001 to 2003. And I have engaged the applicant to look to pursue the pending bills. Only to pursue the pending, which I have carried out the work. And from 2004 to
But
till,
you have said you will pay
no, my lord,
9%.
I'm coming to that also, my lord.
Hmm.
And after that, after the execution of this agreement, that is in page number 11 of this IA, my lord,
Hmm.
it is executed in 2004. Until the filing of this writ petition, my lord, it is 21 years. Till 21 years.
Hmm.
No any communication, nothing. Then I have issued notice to the power of attorney holder that since it is more than 21 years, there is no any communication in regard to the pending bills, which I have interested to pursue.
Then
So on that issue, I have issued notice.
your writ petition is also not maintainable.
And then I have cancelled the power of attorney after serving the notice. Then the applicant is ought to challenge that cancellation of power of attorney. Before coming to this court, ought to challenge that cancellation, my cancellation, this cancellation of the power of attorney.
How you can cancel that?
Have to file an appropriate, this,
How you can cancel that?
I have served a notice
Hmm.
to the applicant that since 21 years, no any communication in regard to
Your
the
writ
bill.
petition is not maintainable at all.
No, my lord.
20 years.
That I have already cancelled and I have appointed another.
You are claiming for payment of the outstanding bill
My lord,
21 years back.
21 years, this 21 years from 2004.
When is the cause of action errors?
My lord, it is 2004 to
This one,
2020.
Your claim.
I have made there, my lord.
No, no.
But-
What is the cause of action errors for claiming this money?
My lord, it is cause of action 2016 for 2021.
How?
This is why it is a delay on the
What is
part of the applicant, my
What
lord.
is the limitation?
Well, it is to be 3 years.
Then
Now it is a delay on the part of the applicant. And my lord, now who is the appropriate person to determine who is the rightful power of attorney? The proprietor of the TM's interface is to be implemented in this, is to be implemented as a party in this applicant in order to determine who is the rightful person of the
okay,
power of
we'll hear
attorney.
the writ petition.
My lord.
If I know the judgment, writ petition will not maintainable when the limitation for filing money suit is
My lord, so this matter may be adjourned
But-
today and fix it for admission
No,
hearing.
we'll hear the writ petition, or else we'll allow the
No, my lord, in the next week, my lord.
why?
In next week, fix it for admission hearing.
No, then we'll
I will produce some authority.
we'll implead what's there. We'll record your objection.
No, my lord, on that day only, on that day. On the next day, I will bring some authority in regard to this cancellation of this power of attorney.
No, not cancellation. We're not on that. We'll see in this application whether he or she may be an affected party when the writ petition, any order is passed in the writ petition.
So, my lord, my prayer, next step maybe,
What's there? You pursue both jointly support and get the payment.
no, my lord, only on the delay of this applicant. Rest of the similar situated person will, they have already received, except my, because of delay on the part of this applicant, my lord.
On being stingy
And
to share 1 crore, you may lose 13 crore.
my lord, I have, applicant has also submitted the application before the authority seeking this payment. But authority says,
Have you gone through the judgment?
my lord, so no, next
For
step I will.
payment, non-payment of outstanding bill.
So, my lord,
When the
in the next time I will.
Under the law for claiming filing money suit. We
On
cannot-
that
we
next-
cannot entertain.
It's on next that I will make it available before this court,
Therefore, we'll hear it next week.
my lord.
Writ petition. We'll implead her. today.
Till then, my lord,
What?
this along with this IA,
We decide the writ petition. What remains there?
my lord, the applicant's power of attorney has been cancelled after issuing
He may
notice.
support you.
So it is their part to challenge debt cancellation, before challenging debt cancellation, before the authority, the appropriate authority.
If I may please, Lordship,
So
We're pleading. It's okay. We'll hear the writ petition. Perhaps she will not, on pleading, she will not object for payment of the outstanding bill.
my lord,
Will you object
Lordship,
for releasing or payment of the claim? Will you object?
Lordship, because if the money it is being paid to him, then I might be my rights may be
Will
curtailed
she
here.
direct him to pay 1 crore to you as per the agreement?
No, Lordship, this work
If
was
that
all,
petition is allowed.
this all work was done by me, and then 1 crore, just paying me 1 crore will be
Then go to
Correct.
civil court. You are not a necessary party. Your agreement has been revoked by issuing a notice to you.
No, I have not received the notice,
You
Lordship,
challenge-
here also.
it ought to be challenged.
Okay.
My lord, till the next week, I will bring all authority in pertaining to this issue.
We are not going into the authority or the
Whether
legality and
after cancelling,
of your-
the power of attorney,
Hmm.
is it right to file application before this appropriate court for imprisonment? So I will make available this authority in the next hearing, my lord.
It's okay. Heard MS
D. Riba.
D. Riba, learned counsel for the applicant, and also heard Mr. You have filed an objection.
I have
We'll
filed,
record your objection.
I have already filed objection.
We'll record your objection. All
And
right.
I have also annexed a notice as well as the cancellation.
Lordship, just
You-
annexing,
You pursue her the moment she is impleaded. You pursue her to go sail and swim together,
My lord, since 21 years,
so that your writ petition is allowed.
my lord, since 21 years, I am in trust of the applicant. But in 21 years, even no single payment has been made, either to the applicant or to the petitioner.
Had the payment been made, you would not have before us.
My lord,
Okay.
because of delay on the part of
Well,
the applicant
and,
only.
and also had Mr. Entaje, learned counsel for the writ petition, opposite party number 1.
Lordship, I go 1, 2, and 4.
Who are you?
Department of DHS.
Food and civil supply.
Civil supply. Why you wrong?
Ketawan also.
Okay, Tabak, learned counsel for. Then you first, right? Learned counsel, why Tabak, Tabang, learned counsel for respondent, opposite party number 1, 2, and 3. I think opposite party is who? No. Opposite party number 2, 3, and 5, as well as Mr. Why did I understand for respondent 4? Then in that case, opposite party writ petition will be remain, Entaje. This is an application praying for implement of the applicant in the connected WPC 228 of 2025. Next para. The opposite party number 1 of the great petitioner has filed the opposite connected writ petition praying for a direction to release the pending outstanding bill amount of rupees 13,92,300, 13 crore 93 lakhs,
ज़्यादा लेट नहीं होगा क्या?
13,250
हाँ सर, आफ्टर वेकेशन ज़्यादा लेट नहीं होगा क्या?
on account of
ये जुलाई के फर्स्ट वीक में करने से कैसा होगा?
the
Before vacation.
works carried out
काम करेगा.
on account of execution of
Fix
the
date ले लेगा लेकिन.
work of carriers bills for transportation of food items under public distribution system.
1 को
to 11 villages under Boleng subdivision, Siang district, Arunachal Pradesh. List of the proprietor of the petitioner number 1, being the family relatives, family friends, stated to have entrusted the work of various bills, carries work of carriers of work of carriers for transportation food items in respect of the opposite villages to which the petitioner, the applicant has carried out. List of the next para. An agreement was entered into between the opposite party number 1 of the writ petitioner and the applicant, whereby it is by which the applicant was entrusted to pursue the payment of the bill of the said work for which the applicant was to be paid at the rate of 9%. They paid the 9% of the total bill amount in respect of the petitioner. First of MS the Learned Counsel for the applicant submits that the applicant has executed the work on behalf of the petitioner, and all along she was pursuing the payment of the outstanding bill on account of the said work, aforesaid work, by virtue of the agreement entered between the parties. However, separating the said agreement and the execution of suppressing the execution and the pursuing of the payment of the bill in respect of a proceed work by virtue of the oral as well as written agreement, the petitioner has surreptitiously approached this court for payment of the outstanding bill amount for the work executed practically through the actually executed through the applicant. List of therefore the petitioner, the applicant is a necessary party to be implemented in this the writ proceedings, proceed writ proceedings. List of next para. Objecting to the prayer for implement, Mr. N. Taj, Learned Counsel with the opposite party number 1 of the great petitioner, submits that the applicant was only entrusted to get the outstanding bill amount released from the department, although the work was executed by the opposite party number 1 of the great person themselves. List of even after lapse of nearly 15 years,
21 years.
21 years. When the applicant failed to get released any get released a single penny, the applicant opposite party number 1 oblique writ petitioner has revoked the agreement between the parties by issuing a notice to the applicant. If at all, if the petitioner, therefore the applicant has no connection with the claim of the petitioner in the connected writ proceedings. If at all the applicant is agreed by the cancellation of the revocation of the agreement, she may approach the appropriate forum, and in any case, she would not be and she would not only be a necessary, but she would not be even a proper party in the connected writ petition. Next para. Consider the submissions of learned counsel for the parties. Where is your objection? You have brought any notice and other thing?
My lord, come to page number 16, 52.
52.
Yes, of my objection.
(52).
Page number 52. Annexure 1. Uh, 54 is cancellation.
Consider the submissions of learned counsel for the parties and also peruse the materials. Next para. Admitted the applicant was admittedly the parties have entered into an agreement entrusting the applicant to pursue the release of the bill, outstanding bill amount on account of the execution of the carriers contract for transportation of food grains. Transportation of food grains. Yes, madam. It said no transportation of food grains and in respect of so and so villages, in respect of various villages in the district of Siang, Arunachal Pradesh. List of the it is also noticed that the petitioner, the opposite party number 1 of the writ petitioner issued notice to the petitioner, applicant for cancellation of the power of attorney.
Lordship,
Power of attorney and subsequent cancellation of the power of attorney. And thereafter subsequently cancel the power of the attorney. To which the applicant refuted that no notice was issued to, no notice was received by the applicant. Next, sir. Be that as it may, the fact remains that the petitioner, the applicant was entrusted with a interest, no, be that as it may, the parties have entered into an agreement to agreement in respect of the aforesaid work, including the for the works, including to get the release, to get the payment released from the department, consequent to which the applicant appears to have taken an action in terms of the agreement. List of the grievance raised in the writ petition is for a direction to release the outstanding amount for the work executed in connection with the carriers contract for transportation food items, wherein both the petitioners, both the applicant and the petitioners have agreed to execute and pursue the payment of the bill. Please step. Considered above, comma, having considered above, I'm of the considered view that the applicant would be a necessary party in the connected writ proceedings, being WPC so and so, huh? Accordingly, no, I deem it appropriate to allow this interlocutory application by allowing by permitting the applicant to be implemented at respondent number 6 in the connected WPC so and so, huh? It is ordered accordingly. The IA states allowed.
My lord, matter may kindly be fixed on 21 July.
In writ petition, in view of the order passed in IA so and so, learned counsel for the petitioner to file an amended cost title. On receipt of the amended cost title, registry to incorporate the newly implemented respondent number 6.
6.
As
Only
agreed to by parties, list their writ petition after 4 weeks.
All right.
Much obliged.
Item number 13 to 17.
Yes.
May I please proceed? Lordship, in this case, Lordship, the pleadings are completed, Lordship. So kindly this matter may be posted for hearing.
Yes.
Pleadings are complete.
Yes.
Notice respondent number 5 and 6. Who is 5 and 6?
Private.
NEC, Lordship. They have already filed, Lordship.
NEC.
Yes, Lordship.
Okay. That Mr. This learned consent for the petitioners. Do listed together.
Lordship.
13 to 16, 17.
17, Lordship.
17. And also at MSG at Learned Additional Senior Government Advocate, as well as Mr. B. Picha, Learned Standing Counsel. Are the pleadings are complete? A list for admission after 4 weeks.
Lordship, after vacation, Lordship.
4 weeks. Next.
Item number 18.
Lordship, I pray for the disposal of this matter. The last occasion also, I prayed for the same, Lordship, but then the Honorable Court asked me, when I, Lordship, submitted that the Lordship, construction is already completed, Lordship. Now, whereas, Lordship, the petitioner have not made the winning farm also a party till that.
Winning.
Yes, the winner farm. Lordship, and then the work is already completed. And then the last time when I
What was the,
submitted the
what was the match?
Lordship, then the court asked me to, Lordship, bring it in record, Lordship, to file in additional affidavits.
You
So
brought
I
it.
have done so, Lordship.
Nothing remains, sir.
Yes, Lordship.
My lord, since the matter is
List on 29, we'll dispose it up for admission. Heard,
29.
mister?
El Murtam.
So anything to say?
Oh, yes, yes, my lord. However, the matter has become infectious. However, observation may be made.
No, no, once it is in practice, nothing remains. Heard, Mr. No, Mr. El Mustem, Learned Counsel for the petitioner, fairly submits that the matter has become infructuous. MS G at the London Additional Senior Government Advocate for the respondents is present. Accordingly, writ petition stands clause as infructuous.
Lordship, similar matter is WPC 378, which has not been 370 and
You get
77
it
and
listed,
70.
you make a mention, we'll see.
78 is not listed.
Close.
It may
Now.
be listed together, Lordship.
Be happy. Look for some other work. Okay.
Much
Obliged.
Yes.
Item number 19.
Award service report in respect of respondent number 4. Mr.
T. Dolo.
Next one. T. Dodo, London Council for the petitioner is present. List after 4 weeks.
Item number 20 and 21.
What is this? IA? IS for what?
I'm praying for the vacation modification.
So we'll vacate it.
Lordship, I need to take instruction from the ID.
For what? For withdrawal?
No, Lordship. To file a affidavit.
Objection?
Yes.
Objection?
Yes, Lordship.
Okay, heard Mr. Arco Learned Counsel for the applicant. Decision application seeking modification. What is this? Alteration? No, vacation oblique modification of the alteration of the interim order dated 07/04/2026 passed in WPC 152 of 2026. Issue notice returnable by 3 weeks. As Mr. Dilip Sekia, Learned Counsel for the opposite party writ petitioner accepts notice on behalf of opposite the Learned Counsel accepts notice on behalf of opposite party public writ petition. No formal notice need be served. However, exit copies be furnished to him. Who else are appearing? You are
I'm for 1 to 5.
Mr. Why is up? Not 1 to 5, 2 to 6. Then State Council appears for 2, 3, 4, 5, and 6. List after 3 weeks. In the meantime, respondent number opposite party number 1 oblique writ petitioner may file objection, if any.
May I pray for a fixed date because
Why?
my position is being disturbed.
What is the case about?
My legally possessed land, after obtaining this interim order, she has completely destroyed my land, the fencing, everything, whatever was there.
3 weeks.
Misused it.
2 weeks. So of no use, 3 weeks, 2 weeks, therefore make it 3 weeks.
Obliged.
Item number 22.
Very peculiar case, Manu, where I can make submissions on low points. Never came across a
Yes.
It's not that simple. It's not a simple matter. What happened?
What had happened is the private respondent was appointed as LDC. Called pursuant to selection process. I was also a candidate. I
Filed an RTI.
RTI. Got my answer sheets. From that, it appeared that I had obtained more marks. I filed this writ petition.
298.
Yes, was allowed. Same.
And the private respondent 292.
Yes.
0.8.
Something, yes. So writ petition was allowed. Appeal was filed. There, by way of additional affidavit, documents were brought in. Then my original answer sheets and lots of other things are not found, missing. Mine. So the appellate court says you review it. It has been reviewed. Now it is now before lordships. The insinuation now is, I am saying he was there in the office. He must have done it. Private respondent saying I am the beneficiary. I might have done it. Government is also saying he might have done it. That is the position. Government, yes. So,
That is not as per the record. Government is making a statement, but it is not as per.
whatever it is, whatever all incidents are not as per record. We can't make anything out of these records. What I will be praying for.
So record is not there.
For an inquiry. My record is not there anymore. When I was given, it was there because it is a certified copy.
On this particular issue.
Just wait. What you were saying?
So I will be praying for an inquiry. Preferably a judicial inquiry by a judicial officer stationed there to find out what has exactly happened. Because I was furnished documents under the RTI Act. Each and every page are certified to be true copies. That was in 2017, 16, something like that. Now in 21, 22, whenever the appeal was filed, after the writ petition was allowed, after 3-4 years, now they are saying, my original documents are missing. That is the situation.
So this writ petition was revived?
Revived, yes.
And the earlier orders are reviewed?
Yes.
So when there is no records, how inquiry will be?
No, that was what I'm saying, because from the answer sheet were checked, must have been checked. If it is not checked very well, I'm out. From the record, it shows there were 3-member board of interviewers. Somebody has checked it, right? True or false, I don't know. The record says they have checked it. Marks were given to me. So they will have to find out who these people were, whether it was actually done or not. My photocopies are there. Photocopies of my answer sheets are there, it appears, from what has been furnished. So there will have to be an inquiry to ascertain whether that certified copy of the answer sheet that was furnished to me is correct or not. If it is false, then I'm out. If it was correct, then I'm in. And in the private respondent, I've raised some issues regarding I having tick mark the answers in the answer sheet, despite the instruction being encircled, was to encircle. He will have to find a separate writ petition saying, no, he was not entitled to the mark. He cannot claim any relief in my writ petition. This is my writ petition. That is the issue.
Regarding this missing records, Lordship, an inquiry was there, Lordship.
Hmm.
Lordship, you find my additional affidavit at page 195.
One?
195, Lordship, Annexure 1. Additional affidavit filed by me.
195.
195, Lordship. Lordship, inquiry report says, Lordship, when this examination was conducted, it was done at Pangin, Lordship. When DC officer was at Pangin, subsequently it was shifted to Boleng, Lordship. And their finding is that during this shifting, it might have gone missing, Lordship. This is one of the findings they have given.
Self-declaration. What is the inquiry?
This is on the base. This is a board proceeding, Lordship.
During 2018, I was the PRDC officer in the same year.
Lordship, page
Regarding the
195.
recruitment, LDC, UDC, and MPs conducted by DC. On receipt, the application was forwarded with it talks about the answer script or the information furnished to the petitioner.
Yes, correct.
Documents provided established by same was provided. I have not seen the original document, therefore have no knowledge about the whereabouts of the original.
Absolutely ridiculous.
These are the Lordship statements recorded during inquiry. And finding is at page 195. There's a board proceedings.
Finding?
The board proceeding is here, Lordship. Can you see page 195, Lordship?
195 is not board proceeding, it's a self-declaration.
Then, Lordship, can we turn to page 194, Lordship?
It's also self-declaration.
Then 193.
All statement. I have got nothing to comment on the procedure. Huh?
May I help, Lordship, to find out the
statement?
Statement is the Lordship. These statements were taken, Lordship, during the board proceeding. During inquiry, their statements were recorded.
Madam?
Our copy is 195.
In fact, I've not gone through this in between what had they developed, but I've just gone through the file, not the papers, writ petition and other thing. So I thought it will dispose it of.
Your Lordship, of course.
Just wait, we'll just finish this.
Yeah, also it's 195 only. Page
195.
195. Annexure 1.
What is this 195?
On top, pagination is then 195.
Huh? What is this 195? Which you are looking? This also 195. What is this? There are two 195. Last page. I was looking at the last page.
Oh, no, Lordship. I'm sorry, Lordship.
I don't know why this.
This one, the pagination.
Yes, yes, sir.
There are two pagination, 192, 195. How is this possible? Huh? 198 is just again 190.
गलती हो गई लोग अभी ऐसे
You corrected later, huh?
What you answer the register?
190. Again, it's starting from 190.
The repetition is still.
This by you only? By whom?
Yeah, correct.
Yes. Board proceedings.
Should I have?
Yeah, it's the findings by the inquiry committee. That's
in a hairy situation. And whose custody it was? You should have, if it is misplaced, somebody has to be fix the responsibility.
Therefore, Lordship, if Lordship turn to page 195, Lordship. Again, last page, Lordship. There's a self-declarations. This is on Tajing Jonnam. He was, Lordship, the PIO at that point of time, Lordship. During, I was the PI of DC office, Siang district, and same year I had received an RT application from Sri John Darang seeking information regarding so and so and so and so. On receipt of the application, it was forwarded to establishment branch of the DC office for providing certified true copy of the documents. The documents were provided by the establishment branch, and same was provided to the information seeker. I have not seen the original documents. Therefore, I have no knowledge about the whereabouts of the original answer sheets of Srimati Osik Kopang. He was the PIO at that point of time. This his statement. So, by looking into the Lordship, this inquiry, Lordship, adequate Lordship inquiry has not been done, Lordship, because those who were in charge of that branch at that point of time, who were in custody of all those documents, because most of them they don't have knowledge. I was not in position, so when this statement is, so therefore I just agree with the what my friend has proposed, Lordship. An appropriate inquiry can be conducted, because on this page, Lordship may not in position to decide the issue, Lordship, unless the finding is there as to the correct status of the missing file, Lordship. Judicial inquiry can be ordered, Lordship.
And you are not saying that these documents which you have given,
no, sir,
is correct, that you are saying that it was given?
Yes, correct, Lordship.
Who is John Darang?
The husband of the petitioner.
Okay.
It was given, therefore they receive also, Lordship. But it's about the whether original is there or not. Now, as on today, Lordship, it's not available.
Who is working? You are working.
No, it's working.
Earlier he was there in terms of the single.
In terms of the single judge's order,
Okay.
judgment.
She is out now.
Lordship,
If your Lordship
There are-
also here, I will have to place the facts first.
no, I'm also agreeable. In fact, I was the one who, in my earlier affidavit in opposition, I was the one who said that there is something fishy, so therefore inquiry needs to be done. That was not accepted by the learned single judge at that point of time, because the situation was such that there are two papers. One is mathematics, another is general studies plus English. English and general studies are clubbed together. Mathematics is another paper. The case of the writ petitioner was that, just in brief, I'm not going to all the details, but just the facts for which I'm going to make my submission. In case of mathematics, there is, according to him, I was appointed wrongly because RTI information shows that there was an increase of 68 marks for him, for her. I mean, the petitioner was a lady. In case of mathematics marks, there was no increase. In case of general studies and English, there was an increase of 68 marks. So therefore, she ought to have been given. Government had filed affidavit at that point of time. Everything was no comments, and no comments. Me on the other side, I have nothing in my hand because I am not privy to anything there. So therefore, I have nothing to say except to say that inquiry needs to be done. That was in para 13 of my affidavit in opposition. What happened later on, when we filed read appeal, at that point of time, we also wanted to know as to how come there was an increase of 68 marks. If there is a mistake also, it could be 3-4 marks, 5-10 marks, but not 68 marks. That much of a difference could not have been done. So therefore, we had simply asked for the records of the recruitment process. Your Lordship may notice one thing, although I have not enclosed here, I forgot to enclose the RTI information which we sought. The RTI information was sought only copy of computer result, copy of result sheet, copy of relevant file, name and address of examination in charge, only those things. After we filed the RTI, the department, the district administration, what they did is they videographed everything and they broke the locker. When they broke the locker, they found that many documents were missing. Number one. Number two, very important, the answer sheets of all the candidates, there were 5 candidates, of all the candidates is there, except for this writ petitioner. So therefore, that is the reason why the writ appellate court said that maybe you need to file a review. So we filed a review and the hearing is, because of that, the matter is being reheard. Now there is something I'd like to point out, Lordship.
Yes.
Why I'm saying maths mark and English mark, Lordship. English paper is the only paper in which 68 marks increase was there. It may also be mentioned that the RTI was filed after almost a year. The second RTI, saying that earlier it was not given. In fact, there is a mention in the writ petition that they were waiting for the deputy commissioner then to get transferred. I don't know for what reason. Now, Lordship, I was also allowed by the review court to file an additional affidavit. So I have filed an additional affidavit. There is something to note, my lord. I am also agreeable to the inquiry, but I'm making this submission because I need a broader inquiry. In the sense, Lordship may see page 124 of my additional affidavit. Affidavit filed by Gagam Moyo.
124.
124. This is, Lordship, one of the candidates, I don't know who, but his mark sheet, his answer sheet was found in the locker. One applicant's answer sheet. Lordship will see the signature here. 124. Signature of the checker, it seems. Then Lordship will see, just to compare this, page number 156. Page number 156. This is the copy of the answer sheet, this is the copy of the answer sheet of the petitioner, in which increase of marks was there. Lordship will see the signature. It appears to be of the same checker. Although it is similar, but it's not exactly similar also, so I have a doubt on this also. But still, if it is the same person, then Lordship may come back to page 124 onwards. The way it is being marked, Lordship, if it is the same person, because it appears to be the same person, or at least it has been made out to be, Lordship will see. 125. The manner in which the marking has been done. The mark, right mark and wrong mark is done by the invigilator, the checker. The candidate's answer is encircled. This is, Lordship, this is in view of the instructions, which your Lordship will find in the same page, 125. This will be five in the instruction, Lordship, same page. Point number 5. Mark the option neatly by encircling it. In case of any confusion due to incorrect marking of opinion, no marks will be given. Has my Lordship found? This is the reason why all the marks, all the answer sheets have been encircled, except for the petitioner, which your Lordship will find at page. This is a part of the record in the writ petition also, at page 157. Lordship will find here. we don't know which is the answer, which is the examiner's marks. And we cannot say that the petitioner did not know about this instruction because his maths answer sheet is encircled. Because of this reason only, that because the original is not there, it is difficult now to say how many marks he got, how many marks she should have got. If it was encircled, even if it is a Xerox copy, no such problem would have been there. And if it is the same invigilator, your lordship may see again, the way it is marked and the way the marks are given in the right side, same invigilator has not done the same at page 125. It is impossible, lordship, if it is the same person. So that is why I was always ready for an inquiry. Inquiry should be done, and the checker, all these things should be taken into account, not just whether it was missing, who was missing, what was missing, all those things. This is very important because this is the only answer sheet in which increase of marks was there, in which there is no encircling. Also, I have marked in the read petition also, this very answer sheets. If lordship will see very closely, in some of the options, it's impossible to find out which is the answer of the petitioner and which is the marking of the invigilator, because two options are marked. If it is in original, or if it is at least encircled, then even if original is not there, that it can be easily found out. That is why this invigilator also needs to be investigated.
Yes, that is what I was.
In fact, since
How do you find who is the invigilator?
they record since they had conducted the examination, they should know. It should be on record.
Very beginning I said, somebody has checked it, he has to be inquired. I'm all for that. It's a matter, so I will not even reply to what my learned friend is saying. I will not even reply to that.
So we'll keep it pending.
Yes, lordship.
Once the report comes, everything.
The list of invigilators and this person, especially this person, it will be in their records.
I will just point out, apparently somebody has checked. That is what I have said earlier also. So they will all have to be done. And it appears from the interview, there were 3 board members. All of them should be. Everybody who was part of the selection process. Because I cannot make my submissions on ifs and buts. So I'm not even responding.
In fact, as a matter of just to give a reply, in fact, since the answer sheets were to be compulsorily encircled, marks could not have been given at all.
Yes, for
to the petitioner.
Petition.
Yes.
I need not file a writ petition here because it was their claim that they had gotten higher marks. It was never in my imagination also that it could be like this. In fact, I had never asked for the answer sheets also, because if I had known it is something like this, my query would have gone in that direction.
To that matter, my simple answer is, if there was something from my part, I would never have annexed it. Rightly or wrongly, they have chosen to give marks. They rightly or wrongly, that they will decide. Now, if on the basis of this, if the private respondent says that I was not supposed to get marks, then he will file a writ petition. This is my writ petition. He cannot claim any reliefs here. Rightly or wrongly, even if without encircling marks have been given. I am not on that manner. I am for the inquiry. My learned friend also is saying on behalf of the government that everybody, there's a proper investigation, taking note of all the persons who were involved in the selection process. They will come out. I can't imagine anything. I can't be making submissions on that. If your lordship wants that I place the facts in sequence, then I can place it.
Yes.
But ultimately, in a nutshell, that is the situation.
There is subsequent, Mr. Tapin, subsequent recruitment process was undertaken. Any subsequent recruitment process?
In this,
For the other post,
for other post,
maybe. I think there was.
maybe.
So according to all of you, without an inquiry, it cannot be decided.
Yes. Yes, I'm making a very, very fair submission. Government has taken a stand where they have said, after termination of the private respondent, he was in custody of these documents and he handed that over. It is in the affidavit. But despite that, I'm saying let there be an inquiry.
After the termination of?
Of the private respondent, since he was the PA, even after termination, these documents were in his custody. Your Lordship kindly pays 185 of the additional affidavit filed by the government. But despite this, I'm saying let there be an inquiry. Has to be, man.
185.
185. Even then, man, there has to be an inquiry. Government's matter, additional. Is your Lordship got it? Paragraph 3. That Srimati Osik Opak secured higher marks than Sri Gagamong as per copies of answer sheet available in his office. It is believed that the documents furnished to Srimati Sasensaj in the year 2018 by the PIO were photocopies of the original answer sheet of an original result sheet. However, it is to inform that the office of the Deputy Governor was moved to Bolang on later part of 2018, wherein a massive number of files and documents were moved from the office of Deputy Governor Pangin to new headquarters in a hurry due to impending general election 2019. It is also a fact that the review petitioner, Sri Gagamong himself, after having been appointed to the present post of LDC cum PA, was in possession of the files related to conduct of LDC exam in question, which was handed over to the head assistant of DC office Bolang after his termination. This is the extent they have taken. But despite that, I am saying there has to be a fair investigation, inquiry. That is what they are saying, that he was in custody. But in fact, I'm not insinuating anything. Can't do that. It will have to come way by an inquiry. Otherwise, this is a very serious statement that these documents were with him after his termination.
The copy of this was given to me only today.
But in spite of it, I'm saying,
I
yes.
consulted my client and he said he was never in possession of that. They are not stupid. He was already an applicant, a candidate in this. They will not let him handle it. If he knew about these things, things would not really come to this.
This was in 2019.
If my
So if we go by the mark sheet itself, according to you, the circle and circle 1
Yes.
cannot be given a marks.
No. Of course, there is one point. But another point I'm saying is, because the same examiner of 2 answer sheets I have shown, another candidate, not me, another candidate, and the petitioner's marks were checked by same examiner. The manner in which the checking has been done is totally different. If I am the person who's checking an answer sheet of 2 answer sheets, my manner would be almost the same.
The manner, what is different?
I have shown, my lord.
Just tell us what is the manner.
First of all, if your lordship sees the paper, your lordship will know.
First one.
Yeah. First of all, encircle paper. Then the examiners, the way examiner is marking whether it's right or wrong, is on the left side. It's on the left side. If it is wrong, it cross mark. If it is right, that tick mark.
In the next
In the other candidates, yes. In case of the petitioner, if it is the same person, it appears to be, the marking is very random. It's sometimes here, sometimes there, sometimes there. And most importantly, on the right side, marks have been given. 2 marks, 2 marks, 2 marks, like that. That thing is not there in case of the other candidate. And also, lordship, if your lordship once I can show also from the writ petition, that same answer script of the petitioner, the marking, the tick mark is such that there are A, B, C, D options in the answers. In A, B, C, D options, in many answers to many questions, there are tick marks in 2 options. We don't know which is of the examiner. We don't know which is of the candidate because both are tick marks. We don't know which marks, or whether marks should have been given, or which was the option. That is why I'm saying the examiner of the petitioner as well as this other person, since the court is only given, we don't know, this person also should be part of the inquiry. That is what I'm saying. If it was
any specific reference you would like to make?
With
So far as the inquiry is concerned, if we direct them to inquiry.
Yes, my lord.
Specific reference.
Specific reference of the examiner
Yes, yes.
of the petitioner in case of GS and English, because the increase in marks is only that of GS and English paper, not of
GS and English.
GS and English. It is one paper.
Okay.
So far as maths is concerned, another paper, they have not claimed any increase in marks. What happened is, in recruitment process was over, marks were given. I was adjudged the select candidate. Later on, they filed RTI, and they said that their marks is say not 200 but 300 because of the increase in marks in the when they got the answer script through the RTI. The answer script in question is GS and English. GS and English were clubbed together as one paper.
So it should be the paper checker
Yes.
Yes.
and
Board, the interview board members also, everybody. There was some typing test also. I will just show you the lordship, the documents, so your lordship. can
no, just
pass.
I just wanted you suggest reference.
Yes.
What if we decide?
Yes, yes. The inquiry should encompass the answer checkers, the board members who took the interview, everybody may not connect.
Typing test also, Lordship.
Everything.
Because since I have no documents to show, I cannot say. But I have been told that the petitioner, in fact, failed in the typing test. The typing test is mandatory. And there is no records also of that.
I think typing test will be mandatory.
Yes, it is mandatory. From the physical marks which is seen, which was given to me through the RTI, it can be seen that her performance was really horrible. So maybe it might have been true. But since the physical marks were not there,
What about you?
I was top.
Excellent.
Yes. Actually, my
Outstanding.
yes. In the typing test, I was number one.
Okay.
No, that is as per.
So we'll keep it pending.
Yes.
Lordship will keep it pending. I don't want to respond to what my learned friend is saying.
It's
because
okay.
this-
The typing, the inquiry should encompass the typing test also.
Judicial inquiry.
It would be better. There is a CJM, I believe, posted at Pangin.
CGM.
I think I
CJM or
will
what?
I'll check up.
CGM,
There was a JMFC there. Mr. Sora was posted there earlier. I don't know now.
There was a JMFC earlier.
He was, if he is there, he could have been taken a good inquiry.
Judicial magistrate first class.
Yes. In fact, we would want a police inquiry.
Whatever, my lord. I'm not even responding because whatever keeps on saying that there is an increase in margin is not my petition was not on the line.
All of you agree that
Yes.
without there being any inquiry cannot be decided.
Yes.
But if the board has taken, decided there's no inquiry, and then the person PIO who has issued admitted that it was issued, then on that basis we can decide also.
That would be very good for me. Because the PIO says that the paper came to me through the establishment branch. Now the person from the establishment branch says, I have not seen the original.
We'll list it on, again on third.
Third of
I'll go through it and I'll think about it.
third of
In that case, may I just point out a few things then?
No, I have taken note of your this thing.
No, I have not submitted. I have just not through.
No, that's what I'm saying. So far the,
Then in that case, I will just point.
direction for judicial inquiry.
I will just point out in that case, my lord. When my first RTA application was filed, the lordship final page 30 on the reply, I asked for my answer sheets. They did not give me. Lordship, imagine that.
That I've seen.
Yes.
No. what I'm
Second time
saying
also
is
they did not
that,
give me.
I mean, not sure of causing an inquiry. So I have taken note of your submission. I have understood. No, let me think about it.
Because there's a
Because
very
it's
peculiar affidavit by the government also. Government is saying that.
That's why I go through it. I'll list it again on third. All right.
Right.
If I I mean, satisfied that it's a judicial inquiry need to be caused, and then we'll pass the order on that. Let me go through it. Because I don't believe in, I mean, not believing, I'm little averse to, I mean, causing an inquiry.
Because the way the facts are now.
That's why,
In fact, Lordship, we had filed a complaint before the police also. That was not, they had not taken.
I've taken note of
Yes.
this thing, and I'll consider it.
Yes.
Let me go through and we'll list it on again third.
Yes. My lord will go through my pleadings. I have explained everything in what manner it has to be resolved.
My lord may also go through my additional affidavit.
No, these are.
It's okay.
Only.
I did not, I mean, this thing, thought that way. Well, I was, I mean, looking, when I was reading the file yesterday,
Understood.
I didn't, it doesn't occur to me. I thought whatever is available, let it be photocopy, we'll go by that.
Initially, the case seemed very innocuous.
Hmm.
The can of worms opened much later.
Hmm.
But my lord, I have restrained from submitting lots of things because no
okay,
point,
it's
no point.
It's
I
okay.
can't, I'm not doing some sort of detective.
And Mr. Deepak Lal, senior counsel assisted by Mr. M. Dojilal, counsel for the petitioner. And also had Mr. S. Tapin London, senior government state respondent, as well as Ms. N. Dangan, constable. Respondent number 6. List the matter on 03/07/2026 for further consideration. Just
Obliged.